Welcome back to Real Clear Politics on Sirius XM. I'm Andrew Walworth, and I'm joined now by Michael O'Neill. He is Vice President of Legal Affairs at the Landmark Legal Foundation. Michael, welcome to the program.
It's great to be with you, Andrew.
So, Mike, I wanted to talk to you today because we had this recent Supreme Court decision having to do with birthright citizenship.
Right.
And it didn't really address that issue frontally, but it did, at least according to the press, limit the ability of federal judges to issue what are called universal injunctions. But every day I'm reading about judges who seem to be doing just that. And most recently, there's this Massachusetts judge who blocked the new budget bill's provision about cutting Medicaid funds for Planned Parenthood. So what's going on?
Yeah, it's a legitimate question to have. And I think a lot of Americans are having this question about what's going on with the federal judiciary. Every time it seems like the Trump administration advances any kind of executive action, you have a district court judge, a lower court judge, there's about 675 of them, issuing some sort of equitable relief and joining the implementation of this. This action, which occurred earlier this week, represents an escalation of this kind of judicial advocacy and judicial activism. What we had here is you had the big beautiful bill was enacted by Congress. This is a piece of legislation that allocated money, tax money. Congress is essentially exercising their core Article 1 authority, determining how our tax dollars are to be spent. And within that big beautiful bill, of course, there was a provision that was cutting funding for Planned Parenthood. The cuts were made pursuant to a core exercise of the Congress's Article 1 function, and Congress exercising their power, deciding how our American tax dollars are to be allocated. Well, this wasn't enough for Planned Parenthood. They ran to court as soon as this bill was enacted and said that they somehow have a right to this money, the hundreds of millions of dollars that are annually allocated previously to Planned Parenthood and were cut. They actually alleged that there was this constituted a bill of attainder in their motion for a temporary restraining order. And what happened? Within hours of this motion being filed, this motion for a temporary restraining order, a judge granted it and essentially stated that the funding that Congress had cut needed to be reinstated. So what do you have here at base? You have a judge infringing on the power of Congress, saying that your cuts to Planned Parenthood are not legitimate, and Department of Health and Human Services needs to continue to fund the Planned Parenthood.
Yeah. So I'm clear on this. One of the differences in the past, or it seems like they've been dealing with executive orders. The Trump will sign an executive order, and they will turn around and find a judge shop, I guess, as they say. Find a sympathetic judge who will then block it either temporarily or and then it goes for review. But in this case, and one of the things that makes it different is this is a bill that was passed by both houses of Congress, signed by the president. And as you point out, this is sort of at the core. This is the core function of what Congress does. Congress is supposed to figure out how to spend the money. And that's exactly what they're doing. And yet this judge up in Massachusetts very quickly turned around and put this 2-week temporary restraining order, I guess, on that decision. So what happens next? I mean, if that's a 2-week restraining order, just for people who are not lawyers, what happens at the end of that 2-week period?
Well, there's going to be a hearing on this, and I would assume that there's going to be an immediate seek of a stay of this order. So the hearing, there is some quibbling about when this hearing is going to occur. The judge, as you said, did schedule it for 2 weeks from now. That's a long time, actually, for a temporary restraining order. A hearing should really be held within days. Awarding multiple weeks where you're going to have this order in effect is really outside the norm. There should be a hearing today, honestly, on this. But what's amazing here is, so you're going to have 2 weeks of ostensibly the Department of Health and Human Services continuing to fund it. I don't think that they're gonna do this. I don't think that there's actually going to be an allocation of direct funding in this intermediate time. I think there's going to be a pause here. But the government would immediately seek to set aside this and to appeal it to the First Circuit, which would, of course, I think, understandably conclude that the judge is exercising authority well outside her purview. Well, this is a non-justiciable issue. This is a political decision that should be made by the political branches of government, i.e. the Congress. And
so it goes from this judge to an appeals court, is that right? And then the appeals court, in your estimation, will reverse the judge.
I certainly would seek to stay. Now, again, right as of right now, the government hasn't moved to stay this emergency order. There's this 2-week window, but I think in this intermediate time, there's not going to be an actual funding of Planned Parenthood. You're not going to see money go from HHS and flow into the coffers of Planned Parenthood, contra the legislation, the big beautiful bill. So I think there's going to be, this order is still going to be in existence. But I think the remedy here is to seek to have this case transferred out of this judge's chambers. I think that the alacrity with which this judge issued this temporary restraining order, we're talking about a 53-page complaint that was filed by Planned Parenthood, and within hours, the judge issued an order. There is no, and the order, by the way, is only a couple pages long. There's no effort to address the usual factors in ruling a temporary restraining order. It clearly indicates that the judge is not objectively approaching these issues that are presented to her. So I think that you would, number one, seek an appeal if there's any kind of injunction that's given, any kind of semi-permanent relief that's granted to Planned Parenthood. Number two, transfer this case out of this judge's chambers to the extent that it's going to continue to exist. Again, I've read the complaint. There's a lot in the complaint, but the primary allegation is that this constitutes a bill of attainder. Now, what's a bill of attainder? A bill of attainder is a legislative act that finds a party guilty of a crime and imposes punishment without a trial. So number one, what crime here are we talking about? No, there's no crime. This is Congress allocating funding or defunding as it sees fit. And there's no punishment. Are you talking about you have some sort of right to you have right to taxpayers' dollars, and cutting that taxpayers' dollars constitutes a punishment? Certainly don't think so. And incidentally, bill of attainders, the prohibition on bill of attainders was originally put in place to prevent punishment of death for a finding of treason. So I think it's kind of ironic that Planned Parenthood is utilizing bill of attainder in the context of death.
Yeah, right. Well, you're listening to Real Clear Politics on Sirius XM. I'm Andrew Walworth. I'm here with Michael O'Neill. He's the Vice President of Legal Affairs at the Landmark Legal Foundation. I do want to also talk about what happened just, I guess, yesterday. The Supreme Court on Tuesday lifted this court injunction that had blocked attempts by DOJ to fire federal workers. So the Supreme Court is involved in these decisions. And is this a big victory for the White House, or what happens?
Certainly, this is another victory. Oftentimes when these cases get up to the Supreme Court, you're seeing that the court recognizes that there's inherent Article 2 authority for the executive branch, that the president has the authority to determine how his executive branch is organized. And if he wants to proffer a plan for downsizing the federal government in context of identifying waste, fraud, and abuse, and these redundant agencies and redundant federal employees. And again, what are we talking about here? The executive action simply was proffering a plan to begin to take these actions necessary to ensure that the government is operating efficiently. There was no actual action here. And this is why I think you saw Justice Sotomayor and even Justices Kagan and Justice Sotomayor join that majority, because they recognized that there wasn't actual executive action. Interestingly, in this case, again, the breakdown was 8-1. You saw Justice Jackson as the lone dissent. And Justice Sotomayor, this is, again, getting into the weeds a little bit on this, but it's interesting nonetheless, is that Justice Sotomayor had to explain essentially what the action in question was to Justice Sotomayor, who apparently had mischaracterized this. You know, when you have Justice Sotomayor in the majority for an 8-1 decision, that there is, who obviously is predisposed to rule against the Trump administration, you know that the district court, Justice Jackson, and the appellate courts who ruled against President Trump were clearly wrong. Yeah.
So we got about a minute left here, Michael. And I'm just wondering, at what point do we get real clarification on this issue of federal judges issuing these universal injunctions? First of all, is it possible that we'll have clarification, or is there always a workaround that if you're an activist judge, you'll find a way to do this? And sure, you may get reversed, but it certainly throws sand in the gears, right?
You know, a couple of weeks ago, I would have liked to have said, you know, with the decision of Trump versus Casa, with the United States Supreme Court speaking as strongly as they spoke and in that majority opinion, you would think that some of these judges, these lower court judges, would get the message, read between the lines, and exercise authority pursuant to the Constitution. But I don't think they're getting the message. This decision out of Massachusetts clearly indicates that these judges want to achieve a certain, implement a certain agenda, and that's an anti-Trump agenda. And again, an anti-democracy agenda. President Trump was elected by the majority of the American people to implement a specific agenda. And these judges are really putting policy and politics over their role of judges to objectively analyze the cases before them. So I don't know if it's going to be by hook or by crook, if it's going to be by drips and drabs, but at some point, these judges are going to have to get the message that they need a function consistent with their Article 3 authority and not implement politics into their decisions.
Yeah. All right. Well, Michael, great stuff. Thank you for explaining this to us. It's a complicated stuff, but it's good to have an actual lawyer on the show every now and then to tell us what's going on. I've been talking with Michael O'Neill of the Landmark Legal Foundation. I'm Andrew Walworth. That's our program for today. Thank you for listening. We'll be back here with more Real Clear Politics tomorrow. Have a great evening.